Welcome to Once Upon a Case. If you enjoy legal cases, please don't forget to like and subscribe. Alright, picture this. It's 1902 London. The city is buzzing with excitement because King Edward VII is about to be crowned. The coronation is such a big deal, people in London are scrambling to find the best views in town. Enter our two main characters, Mr. Krell and Mr. Henry. Henry's desperate to witness the festivities, and Krell owns a room with a prime view right along the royal procession route. They make a deal. Henry will rent the room for 2 days, just for the coronation. He pays a chunk up front and promises to pay the rest later. But then, disaster strikes. The king gets sick. The coronation is postponed. The parade never happens. Suddenly, Henry's fancy room with a view? Completely useless. He decides not to pay the rest, arguing, "Hey, the whole reason I wanted the room doesn't exist anymore." Krell, though, says, "A deal is a deal. Pay up." So off to court they go. Now here's where it gets interesting. The court had to answer a big question. If the main purpose of a contract disappears, does that contract still stand? The judges looked at the facts. Both Krell and Henry understood the room was for one thing only, the coronation. Nobody cared about staying there any other day. The whole contract was built around this once-in-a-lifetime event. So the court ruled in Henry's favor. They said, look, when the foundation of a contract, the thing both sides assumed was definitely going to happen, vanishes, the contract collapses too. This became known as the principle of frustration of purpose. It's a mouthful, but here's what it means for all of us. Sometimes, life throws a curveball that nobody could predict. If that curveball destroys the very reason you made a deal, you're not necessarily stuck with it. Think about it. If you rent a boat for a parade that gets rained out, or book a venue for an event that can't legally happen, Krell v. Henry is the reason you might not have to pay for something you never got to use. But there's a catch. Not every inconvenience counts. The event has to be truly fundamental to the contract. If it's just harder or less profitable, that's not enough. The purpose has to be totally wiped out. So next time you're about to sign on the dotted line, remember the tale of Krell and Henry. A story about kings, contracts, and what happens when even the best laid plans go sideways. Thanks for watching. If you found this interesting, hit that like button, and let me know in the comments what other legal cases you want to hear about.